August 2022 at 23:49.
My ladies and my lords, this is the same KISII transmitting or sending results, one from Mount Elgon, 1,000 kilometers away from Nyeri town. 2 hours later, how is that possible? When each KISII was supposed to have, each polling station had its own unique KISII, which was supposed to transmit from this, its own unique IP address. Because of time, I cannot demonstrate the thousands of forms that we have identified with the same issue. My ladies and my lords, this is how the staging or the complaint that we raised happened. We did not give this court a fiction. What we gave the court happened. Now, staging, and as we have shown, the 11,000 polling stations that we had complained were staged were transmitted all from one IP address. Every KISII was required to have its own unique IP address. The only way 11,000 KISIIs or results can be transmitted from one IP address is if they were collected, and as probably my senior Paul Mwangi had. May I have, I beg your pardon, my time is up.
Yes, 2 minutes.
Yes. My ladies and my lords, the manner in which the election was stolen, the reason why staging was necessary was forms were intercepted like this. Whoever intercepted them then had time to decide which ones they could manipulate before uploading them and sending them to the IBC portal. The other reason that we know there was manipulation is because the original Form 34A is a colored form that should have appeared at the National Tallying Center if transmitted in one transaction as a colored form. All the forms that are on the IBC portal are in black and white. At what point were they altered from JPEG to PDF? When did that modification happen? And what other modification was done to the form? We submit to you that we have shown that not only was it possible, it did happen, and the fingerprints of those who interfered in the systems are still there. Thank you for your time. I don't know whether to be that generous. I donate the 29 seconds to the court. Thank you very much, at the insistence of my seniors.
Please, the court, my name is Kirago Kimani. My learned friend, Mr. Katwa Kigen, had gotten the attention of the court, but was asked to wait until Ms. Soweto had completed her presentation. I would wish to respond to what she has just addressed you on, because this is new material, and would like to have direction
Mr. Kirago,
these matters.
By the court to demonstrate
Yes.
how this was happening.
Yes.
What we do with the demonstration Mr. Mahat, on your side, did demonstrate.
Mr.
And
Mahat,
they have demonstrated.
I appreciate what your ladyship is saying, but Mr. Mahat, with respect, is not on our side. He is the referee. My client was a candidate. We are not on the same side. We may be respondents, but he called this march, not for us, but is required by the Constitution.
Mr.
But anyway,
Kirago,
the long and
I'm
short of
sorry.
it, yes.
I'm
The long and
sorry.
short, yes.
We are not going to give you time.
Much obliged.
Yes, thank you. Proceed with, there were responses from the other petitioners. Beginning with number 1, the same order we followed. You have responded. So who was next? It was, I think, Senior Counsel Jan Mohammed was her client. The same order we followed so that we don't waste time. If you can't use the 15 minutes, please.
Your Ladyship, Madam Chief Justice. Your Ladyship, Madam Deputy Chief Justice, my lady and my lords, I was very generous in my opening, so I'm sure I'm going to be just as generous and patriotic as I am in my rejoinder. I had donated, I was the first one to donate 7 minutes in my opening.
Okay.
My lady, on behalf of the petitioner, in number 1, that's the second petitioner, we had filed a rejoinder of the submissions after our original submissions. And my lady, the petitioner's case is very simple. All it was the petition was limited to a legal issue. It was the role of the commissioners vis-a-vis the chairperson.
I saw people murmuring, and I want to get this correct.
I'm sorry.
Is it that we should then, because I thought you had a response, you had any question to answer?
In fact, my lady, the question I'm going to be answering is actually the rejoinder as to the role, as the answer to the role.
For purposes of orderliness, because we are trying to get our proceedings as orderly as possible, then we can start with the rejoinder by the first petitioner, then the others will answer the questions with their rejoinder.
Because my actually rejoinder is the response to the question of what the role of the other commissioners was vis-a-vis the chairman and the commission. Okay. That's what my entire petition is based on.
So then we start with the main petition,
that's
their rejoinder, then we come to you. I'm sorry.
Begin with Senior Counsel Otinda Modo.
If it may please your ladyship, this honorable court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus 1. Your ladyship, this honorable court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at the same time, in paragraph Sunkuli, says it was 56.17, looking at the same Kimskit. It will be noted by this honorable court that at various times, the IBC gives different figures. At one time, it uses a figure of 65.4%. At another time, it uses a figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which IBC proceeds is wrong, and that the reason for this moving target is so as to manipulate the question voter turnout to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, Your Ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The IEBC did publish a gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the KISII, the figure they are seeking to use is 22,005,541. We wish to submit, Your Ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the KISII, which ends up with a moving target. We wish to submit, Your Ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, why is it wrong to use the vote turnout as per the so-called KISII? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you are to rely on the KISII and all 42,298 KISIIs failed and in only one polling station functioned, then it means that if the 700 voters in that polling station voted, the IEBC will be telling us that the voter turnout is 100%. That would be the logical consequence of that narration. The voter turnout cannot be something that depends on the interpretation of the IEBC at its convenience. It must be the denominator as a percentage of the total registered voters. My second point, my lords, my lady, and I do not want to go too much into this, the question of the infrastructure, what the IEBC called the impregnable military style infrastructure. I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, Your Ladyship, my lady, that the one question they failed to answer was why was there stoppage of the streaming of the results at Bomas? They have not answered that, because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your Ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, Your Ladyship, that in accordance with Article 141, only if there is a result properly declared can you even move to challenge it. In this case, none was done. Your Ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, your ladyship, you are the Chief Justice and you are the President of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, your lady, it is the decision of the majority that must be the decision of the court. And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the IEBC that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision by IEBC itself because it's made by the majority. I wish to stop there for now. Thank you, my lord.
My Lady Chief Justice, members of the court, I address the court firstly on the issue that in making your final decisions, in reviewing your own views, the views of the respondents, petitioners, parties who have addressed you, we would be praying for the prayers and orders that we have sought. And in doing this, may I first refer to the principle that would be applicable in approaching your decision and judgment. In this context, AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the commission should have an executive chairperson. That we have learnt much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for the 38(3)(c). The tallying has to be done by the IBC. The verification has to be done by the IBC. The declaration decision has to be made by the IBC. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki, in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor. No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity. No, there was not. And it is very important to realize that we do not use these exaggerated criteria in order to come to a justification of plain wrong. Is it, the issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, Unilateral Declaration of Independence, to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still